Republic Act 8291, also known as the GSIS Law, an act amending Presidential Decree Number 1146, as amended, expanding and increasing the coverage and benefits of the government service insurance system, instituting reforms therein for other purposes.
The coverage of GSIS law covers all government workers, except members of the judiciary and constitutional commissions who are covered by separate retirement laws. Next is contractual employees who have no employee-employer relationship with their agencies. And lastly, uniformed members of the armed forces of the Philippines and the Philippine National Police, including the Bureau of Jail Management and Technology and the Bureau of Fire Protection, who are excluded from coverage of GSIS law. First is, it does not include barangay and sangguniang officials who are not receiving fixed monthly compensation. And second, it does not include employees who do not have monthly regular hours of work and are not receiving fixed monthly compensation. There are two types of beneficiaries according to GSIS law. First is the primary beneficiaries, who are the legal dependent spouse until he or she remarries. Second is dependent children under RA 8291 of Section 2. Next is the secondary beneficiaries, who are dependent parents and legitimate descendants subject to restriction of dependent children under RA 8291 Section 2. Who are the dependents of GSIS law? First is legitimate spouse dependent for support upon the member or pensioner. Second is legitimated, legally adopted child, including the illegitimate child. And lastly, an employee over 60 years of age, if he had been paying contribution to the system prior to age and has not been compulsory retired.
Now we go to the benefits of the GSIS law. How do we compute our basic monthly pension? So in Section 9, there are two ways on how we are going to compute our basic monthly pension. First is that basic monthly pension is equals to 37.5% of the revalued average monthly compensation. Plus, if the worker has rendered for more than 15 years of service, he shall receive an additional 2.5% of the said revalued average monthly compensation for each year of service in excess of the 15 years, provided that his basic monthly pension shall not exceed to 90% of the average monthly compensation. Second is that the basic monthly pension may be adjusted by the President and the General Manager of the GSIS and approved by the President of the Philippines in accordance with the rules and regulations of the GSIS law, provided that the pensioner shall receive not less than 1,300 pesos, or if the pensioner has rendered service for at least 20 years after the effectivity of this act, he shall receive for not less than 2,400 pesos monthly. Now let's proceed to the computation of service. When are we going to start counting or computing our service? So according to Section 10 of the GSIS law, the computation of service shall begin from the original date of the appointment or election, including those period of service at different times under one or more employer, those jobs performed overseas but under the authority of the Republic of the Philippines, and also those jobs prescribed by the GSIS in coordination with the Civil Service Commission. Now, in cases of reinstatement in the service of an employer and by subsequent retirement or separation, which is compensable under this Act, all service credited for retirement, resignation, separation shall not be included in the computation of service. Now let's proceed to Section 11 of the GSIS law, which is the separation benefits. So under Section 11, separation benefits consist of number 1, a cash payment equivalent of 100% of the member's average monthly compensation. For each year of service, he paid contribution, but not less than 12,000 pesos, payable upon reaching the age of 60 or upon resignation or separation, whichever comes first, provided that the member has rendered at least 3 years of service but less than 15 years. Number 2 is a cash payment equivalent to 18 times his basic monthly pension payable upon resignation or separation, plus an old age benefit equivalent to his basic monthly pension payable monthly for life upon reaching the age of 60, provided that the member has rendered at least 15 years of service and is below 60 years old from the time of his resignation or separation. Next is the unemployment benefit or involuntary separation benefits, which is under Section 12 of the GSIS law. So unemployment benefits in the form of monthly cash payments equivalent to 50% of the average monthly compensation shall be paid to the permanent employee who is involuntarily separated from service due to abolition of his office or position, which is usually resulting from reorganization, provided that the member has been paying integrated contributions for at least 1 year prior to his separation.
Let us now go to retirement benefits. The age of compulsory retirement under the GSIS law is 65 years old, while the age for optional retirement is 60 years old. The rationale for compulsory retirement was elucidated in the case of Veronilla versus GSIS. The Supreme Court said that the compulsory retirement of government officials and employees upon reaching the age of 65 years is founded on public policy which aims to maintain efficiency in the government service and at the same time give the retiring public servants the opportunity to enjoy during the remainder of their lives. Now, in the year 2019, during the 18th Congress, Senate Bill 715 was passed, and this bill seeks to lower the optional retirement age of public school teachers from 60 years old to 55 years old. For a person to avail of the retirement benefits under the GSIS law, the following conditions must be satisfied. First, that the retiree is a member that has rendered at least 15 years of service and that he is at least 60 years of age at the time of the retirement and that he is not receiving a monthly pension benefit from permanent total disability. This is according to Section 13-A of Republic Act 8291. A retiree may avail of the following options. First, a lump sum equivalent to 60 months of basic monthly pension or BMP payable at the time of retirement and an old age pension benefit equal to his BMP payable for life. And this old age pension benefit will start upon the expiration of the 5 years covered by the lump sum. Or the second option would be cash payment, which is equivalent to 18 times his BMP, and monthly pension for life payable immediately. So now there is a question. What happens when the official or employee has already reached the age of 65 but has not yet completed 15 years of service? For example, if a person enters government service at the age of 51, So by the time he reached the age of 65, he has not yet completed the requirement of 15 years of service. This is answered by the Supreme Court in the case of Rabor versus Civil Service Commission. The Supreme Court held that the head of the government agency concerned is vested with discretionary authority to allow or disallow extension of the service of an official or employee who has reached 65 years old without completing the 15 years of government service. However, this discretion is to be exercised conformably with the provisions of Civil Service Memorandum Circular number 27, series of 1990, which provides that the extension shall not exceed 1 year. Let us now go to disability benefits. First, we have to define what is a disability. The GSIS law defines disability as any loss or impairment of the normal functions of the physical and or mental faculty of a member which reduces or eliminates his or her capacity to continue with his or her current gainful occupation or engage in any other gainful occupation. There are three types of disability under GSIS law. They are permanent total disability, permanent partial disability, and temporary total disability. Let us discuss them one by one. Permanent total disability. This is the disability caused by injury or disease resulting in complete, irreversible, and permanent incapacity to work or to engage in any gainful occupation. So this situation covers complete loss of sight for both eyes, loss of 2 limbs at or above the ankle or wrists, permanent complete paralysis of 2 limbs, and brain injury resulting to incurable imbecility or insanity. What is the benefit of permanent total disability? Under the GSIS law, a member is entitled to the monthly income benefit for life equivalent to the BMP. However, the availment of such benefit is subject to the following conditions. First, that he is in the service at the time of the disability, or if separated from service, he has paid at least 36 monthly contributions within 5 years immediately preceding his disability, that he has paid a total of at least 180 monthly contribution prior to his disability, and that he is not receiving old age retirement pension benefits. Take note also that the member cannot enjoy the monthly income benefit for permanent disability and the old age retirement simultaneously. If the member does not satisfy the conditions above but has rendered at least 3 years of service, he shall be allowed to advance the cash payment equivalent of 100% of his average monthly compensation for each year of service he has paid contribution, but not less than 12,000 pesos, which should have been his separation benefit. Now let us go to permanent partial disability. According to GSIS law, when a member is incapacitated to work for a limited period of time because of complete and permanent loss of any of the following body parts, such as any finger, any toe, 1 arm, 1 hand, 1 foot, 1 leg, 1 or both ears, hearing of 1 or both ears, sight of 1 eye, then such government employee or member is considered to have suffered from permanent partial disability. What is the benefit of permanent partial disability? Under the GSIS law, a member is entitled to cash payment in accordance with the schedule of disabilities to be prescribed by GSIS. However, again, the availment of such benefit is subject to the conditions given in Section 16, Paragraph A of GSIS law. We now go to the last type of disability, which is temporary total disability. Under the GSIS law, a member is considered to have suffered from temporary total disability when he is momentarily incapacitated to work or engage in any gainful occupation as a result of impairment of physical or mental faculties, which can be rehabilitated or restored to their normal functions. Now, what is the benefit of temporary total disability? Under the law, a member is entitled to 75% of his current daily compensation for each day or fraction thereof of total disability benefit to start at the fourth day, but not exceeding 120 days in one calendar year when he has exhausted all sick leaves or CBA sick leave benefits, provided that he was in the service at the time of the disability, or if separated from service, he has rendered at least 3 years of service and has paid at least 6 monthly contributions in the year preceding his disability. The temporary total disability benefits shall in no case be less than 70 pesos a day. Take note also that an application for disability must be filed with the GSIS within 4 years from the date of the occurrence of the contingency.
Section 20. Survivorship Benefits. When a member or pensioner dies, the beneficiaries shall be entitled to survivorship benefits provided in sections 21 and 22 hereunder, subject to the conditions therein provided for. The survivorship pension shall consist of 1. The basic survivorship pension, which is 50% of the basic monthly pension, and 2. The dependent children's pension, not exceeding 50% of the basic monthly pension. Next, Section 21, Death of a Member. A. Upon the death of a member, the primary beneficiary shall be entitled to 1. The survivorship pension, provided that the deceased was 1. In the service of the time of his death, or, if separated from the service, has at least 3 years of service at the time of his death, and has paid 36 monthly contributions within 5-year period immediately preceding his death, or has paid a total of at least 180 monthly contributions prior to his death. And then 2, the survivorship pension plus a cash payment equivalent to 100% of his average monthly compensation for every year of service, provided that the deceased was in the service at the time of his death and with at least 3 years of service. And then 3, a cash payment equivalent to 100% of his average monthly compensation for each year of service with paid contributions, but not less than 12,000 pesos, provided that the deceased has rendered at least 3 years of service prior to his death, but does not qualify for the benefits under item 1 and 2 of this paragraph. Next, the survivorship pension shall be paid as follows. Ito naman po yung pagbayad. 1. When the dependent spouse is the only survivor, he or she shall receive the basic survivorship pension for life or until he or she remarries. Number 2, when only dependent children are the survivors, they shall be entitled to the basic survivorship pension as long as they are qualified, plus the dependent children's pension equivalent to 10% of the basic monthly pension for every dependent child not exceeding 5, counted from the youngest and without substitution. Number 3, when the survivors are the dependent spouse and the dependent children, the dependent spouse shall receive the basic survivorship pension for life or until he or she remarries, and the dependent children shall receive the dependent children's pension mentioned in the immediately preceding paragraph number 2 hereof. Next. In the absence of primary beneficiaries, the secondary beneficiaries shall be entitled to 1. The cash payment equivalent to 100% of his average monthly compensation for each year of service he paid contributions, but not less than 12,000 pesos, provided that the member is in the service at the time of his death and has at least 3 years of service. And then number 2, in the absence of secondary beneficiaries, the benefits under this paragraph shall be paid to for his legal heirs. And then D, for purposes of the survivorship benefits, legitimate children shall include legally adopted and legitimated children. Next, Section 22, Death of a Pensioner. Upon the death of an old age pensioner or a member receiving the monthly income benefit for permanent disability, the qualified beneficiaries shall be entitled to the survivorship pension defined in Section 20 of this Act, subject to the provisions of paragraph B of Section 21 thereof. When the pensioner dies within the period covered by the lump sum, the survivorship pension shall be paid only after the expiration of the said period. So next, Section 23, Funeral Benefits. The amount of funeral benefits shall be determined and specified by the GSIS in the rules and regulations, but shall not be less than 12,000 pesos, provided that it shall be increased to at least 18,000 pesos after 5 years and shall be paid upon the death of A, an active member as defined under Section 2, letter E of this Act, or B, a member who has been separated from service but who may be entitled to future benefits pursuant to Section 4 of this Act, or C, a pensioner as defined in Section 2 of this paragraph O of this Act, or D, a retiree who at the time of his retirement was of pensionable age under this Act but who opted to retire under Republic Act No. 1616. Section 24, Compulsory Life Insurance. All employees, except for members of the Armed Forces of the Philippines, or AFP, and the Philippine National Police, or PNP, shall, under such terms and conditions as may be promulgated by the GSIS, be compulsorily covered with life insurance, which shall automatically take effect as follows. 1. For those employed after the effectivity of this Act, their insurance shall take effect on the date of their employment. 2. For those insurance will mature after the effectivity of this Act, their insurance shall be deemed renewed on the day following the maturity or expiry date of their insurance. And 3. For those without any insurance as of the effectivity of this Act, their insurance shall take effect following said effectivity. Section 25, Dividends. An annual dividend may be granted to all members of the GSIS whose life insurance is in force for at least 1 year in accordance with the dividend allocation formula to be determined by the GSIS. Section 26, Optional Insurance. Subject to the rules and regulations prescribed by the GSIS, a member may apply for insurance and/or pre-need coverage, embracing life, health, hospitalization, education, memorial plans, and other such plans as may be designed by the GSIS for himself and/or his dependents. Any employer may likewise apply for group insurance covered for its employees. The payment of the premiums or installments for optional insurance and pre-need products may be made by the insured or his employer and/or any person acceptable to the GSIS. Section 27, Reinsurance. The GSIS may reinsure any of its interests or part thereof with any private company or reinsurer, whether domestic or foreign, provided that the GSIS shall submit an annual report on its reinsurance operations to the Insurance Commission. Next, prescription. Section 28, prescription. Claims for benefits under this Act, except for life and retirement, shall prescribe after 4 years from the date of contingency.
Let's proceed to Limited Portability Law, a Republic Act 7699. What is Limited Portability Law? According to its rule, covered worker who transfer employment from one sector to another or is employed in both sectors shall have creditable services or contributions on both systems, credited to his service or contribution record in each of the systems, and shall be totalized for purposes of old age, disability, survivorship, and other benefits in either or both system. Take note, all contributions paid by such member personally and those that were paid by his employers in both systems shall be considered in the processing of benefits which he can claim from either or both systems. How advantageous for SSS and GSIS member is the Limited Portability Law? This is advantageous to the SSS and GSIS members for purposes of death, disability, or retirement benefits. In the event the employee transfer from the private sector to the public sector or vice versa, their creditable employment services and contributions are carried over and transferred as well. Let's define what's totalization under Section 2 of RA 7699. This refers to the process of adding up the periods of creditable services or contributions under each of the systems, SSS or GSIS, for the purpose of eligibility and computations of benefits. How about portability? This refers to the transfer of funds for the account and benefits of a worker who transfer from one system to the other. Question: how the benefits are computed under the Limited Portability Law? All contributions paid by such member personally and those that were paid by his employers to both systems shall be considered in the processing of benefits which he can claim from either or both systems, provided, however, that the amount of benefits to be paid by one system shall be in proportion to the number of contributions actually remitted to that system. When totalization shall not be applied. The totalization shall not apply to the following instances. First, if a worker is not qualified for any benefits from both systems. Second, if a worker in the public sector is not qualified for any benefits from the GSIS. Or third, if the worker in the private sector is not qualified for any benefit from the SSS. Take note, for purposes of computations of benefits, totalization applies in all cases so that the contributions made by the worker member in both systems shall provide maximum benefits which otherwise will not be available. In no case shall the contribution be lost or forfeited. However, if after totalization the worker member still does not qualify for any benefit as listed in the law, the member will then get whatever benefits correspond to his or her contributions in either or both systems. Thank you for watching and listening to our presentation.